Hey everyone, Judicial Watch President Tom Fitton here with our weekly update on social media. Thanks for joining us this week. As you can see, I'm at an undisclosed location, but the heavy lifting never stops for Judicial Watch. A lot of great news this week. Two major court actions that resulted in big victories for the rule of law against the radical left that has contempt for the rule of law. I'll talk about that. Plus, there's a criminal trial going on looking into the Clinton gang. So I'm going to talk about that as well, including information that implicates Hillary Clinton in the criminal conspiracy, in my view, a criminal conspiracy against Donald Trump. First up, I want to talk about the trial of Michael Sussmann, the top campaign lawyer, or at least one of two top campaign lawyers for the Clinton campaign and the DNC and such. And he went to the FBI, according to John Durham, and lied about who he was representing when he conveyed, it looks like to be fake information, there's no doubt, right, really, about Trump and Russia. So the fake information was generated, it looks like, as a part of a spy operation against Trump and his organization, the Trump organization, that somehow the Trump entities were in communication with Russian banks, which of course isn't illegal to begin with. So the first response from the FBI general counsel should have been, well, what's the legal issue here? Instead, the FBI actually investigated Trump because it fit in nicely with the FBI's smearing of Trump to date and attacks on Trump, where they were targeting him and spying on him, again, based on lies from the same gang. Remember, the Clinton campaign was behind, according to Durham, and what the evidence has shown, not only in the trial, but in the material presented in the run-up to the case, these specific fake allegations about the internet communications. Now, the internet communications, the analysis was done, it looks like, at least based on what Judicial Watch was able to uncover separately, based on spy operations against Trump. So you had the Clinton operatives spying on Trump, and it continued even after this FBI meeting, and it looks like the evidence shows it continued when Trump was in the White House. So Judicial Watch separately uncovered that it was likely done pursuant to a contract with the Pentagon. Not that the Pentagon hired them to spy on Trump, but they were using the resources and access granted to them as the result of the Pentagon contract to target Trump. So it's a really terribly complex scandal in that regard. The only question I have is, when you look at what was going on in terms of the Obama administration targeting Trump and other agencies targeting Trump even after he became president, is which government agencies weren't spying on Trump? Which government agencies weren't being misused and abused to spy on Trump? So the trial against Sussman has proceeded. The specific charge, as I said, is lying to the general counsel of the FBI. Sussman supposedly came in and said, look, I'm just coming in here as a citizen. I'm not here representing a client, when in fact, he was representing clients. The evidence shows that he was billing clients for the meeting. And not only that, but the information, in addition, and he should be charged for this in my view, but he wasn't, was fake. And they had every reason to believe it was fake. In fact, there was testimony that just happened as I go to record this by Clinton's campaign manager at the time, Robbie Mook, that guess who authorized the leak and disclosure of this information? Hillary. Hillary did it. Now, we've already generally known that, but now we have testimony under oath that Hillary did it, that the conspiracy targeted Trump with fake information to be funneled not only through the media, which would be, frankly, a civil, raise civil claims, but to try to knowingly pass bad information through the FBI and have them chase down rabbit holes, frankly, even if the FBI was willing to do it, is criminal. And what I'd like to know is why, if Robbie Mook, after testifying that Hillary Clinton did it, why isn't Hillary Clinton in the dock? Why isn't Durham questioned Hillary Clinton? Now, I guess technically he could have done it secretly. We don't know, but I doubt that happened. And because now we have confirmation that Hillary Clinton specifically authorized the release of fake Russia smears to try to destroy Donald Trump. Incredible, incredible developments. Now, it'd be even better in terms of developments if Durham is going to do something with this. And my concern is that this is really the beginning of the end for the Durham investigation, in the sense that there have been 3 years of investigations, only 3 prosecutions. The first prosecution of the FBI lawyer who lied in the FISA court process to get spy warrants on Trump and his team. And basically, by targeting Carter Page, they were targeting Trump, and that was the goal. And then the Russian operative who wrote the dossier in part for the Clinton gang, he's been indicted for lying as well. And then, of course, Sussman. That's it. 3 years, 3 indictments. Are there going to be more indictments? Are there going to be more prosecutions? Now, the first one against the FBI lawyer ended with a kind of a disaster of a plea deal that resulted in insufficient punishment. We don't know how the one against the Russian operative is going to go. And this one is going forward against Sussman here in D.C. in a trial that has on its jury significant supporters, people who admit they support Hillary Clinton or they support Democrats generally. And one is an anti-Trump activist. I mean, you know, if he gets a conviction out of this jury, Sussman's even guiltier than guilty. That's my view. And of course, if he doesn't get a conviction, it highlights the difficulty of getting justice for Donald Trump in a jurisdiction like D.C. that is overwhelmingly anti-Trump. I mean, the numbers of just Republican registrants in D.C. is laughably small. I think it's less than 10%. So that's this difficulty. And let's hope and pray, that Sussman gets a fair trial. I mean, he deserves that as a citizen. You know, as I've often said, and is that the FBI, in my view, is no crime victim here. I mean, even technically, if it is a crime victim, Sussman, I think, has a reasonable point, and he's kind of implied that his lawyers implied that they will try to make this point, is that they all knew what was going on. I mean, Baker, the FBI general counsel, wasn't born yesterday. He knew Sussman. He knew who he was representing generally. So it wasn't like this was a major issue in terms of, and it's literally the language they use, material to what the FBI needed to know about what was going on. But the other big problem for them is that one of the reasons you might disguise the origin of the information is because if they knew the detail of the origin of the information, that it was the Clinton campaign, and that there was this obvious political motive behind it, they probably would have dismissed it even sooner than they ultimately did. And my concern is, frankly, they really never dismissed it, even though they knew it was false. So this scandal just goes so far beyond Sussman. There should be many, many prosecutions by Durham just on the way this information was handled and or mishandled by the FBI, Justice Department, and frankly, all sorts of people in the bureaucracy who knew better, but were happy to try to target and destroy Trump based on these fanciful allegations. So we'll see what happens with the Sussman trial. And in the meantime, Judicial Watch ain't waiting on Durham to either finish this prosecution or do anything else or write a report. We've got litigation ongoing to try to get information still about the Russiagate scandal and documents that continue to be withheld from the American people. As I disclosed to you last week, a federal court just ordered the FBI to release information that they were hiding, or at least more information that they were hiding either publicly or to the court privately, if need be, about who else was involved in the decision to spy on Trump. We're getting that information. We got the underlying document initially, not Durham. At least we disclosed it publicly. And we sued the CIA, for instance, about communications they had with Sussman and the Clinton operation about these fake allegations. So we ain't waiting on Durham. And that's what's important to know. We need to have anyone who is, that every American or group or congressional entity who wants the accountability to do their work, to do their heavy lifting. Now, Congress is completely AWOL on this. Devin Nunes is out of Congress. The Republicans are in the minority. Frankly, even when they were in the majority, they had difficulty getting this information out. And Judicial Watch was able to get information that they were unable to get. So Congress needs to get on the ball, and we can talk about how that would ever happen. Certainly, the agencies also need to do the prosecutions. And so Durham deserves credit for at least doing this a little bit. You can see how difficult it is to get anything done. So this is pretty extraordinary stuff. And the other interesting piece of news is how small a world this anti-Trump activism is. So the top lawyer, or the deputy campaign lawyer who was overseeing this anti-Trump opposition research, is now a top lawyer for, guess who? The Soros Foundation. So it's a small world, isn't it? I thought that was curious as well, and I thought you would have been interested in that point, because you can be sure the media isn't going to remind you of that. So we'll keep an eye on the Sussman trial. The jury is going to get the case probably the end of next week, and or the week after that. And so we should have a verdict before you know it, or maybe we won't. Maybe it'll be hung jury. So, but in the meantime, Judicial Watch will continue its independent investigation. And that's what I love about Judicial Watch, is that we don't wait for anyone else to do the work, because we don't presume the work will get done unless we do it ourselves. And to that end, this is a good example of, if Judicial Watch doesn't do it, no one else will, is our successes in California. And I don't know if you've been watching the news or seeing the news, but I hope the news to date, and if not, this is going to be great news for you, is that Judicial Watch obtained a great victory for the rule of law, where a state court judge in California ruled that the California quota mandate requiring a certain number of women to be on boards of directors of corporations was illegal and unconstitutional. This came after a 28-day trial, our legal team deserves so much credit. I mean, one of the wonderful things about Judicial Watch, and one of the pleasures and honors of my job, is to be able to come and communicate and talk about the great work my colleagues are doing. I know you see me on YouTube and on social media and such, and on television, but remember, I'm not a lawyer. I'm not in court for 28 days defending the rule of law, questioning witnesses. It's Judicial Watch lawyers who are doing it. So we had a team of 4 lawyers there 24/7, practically speaking. And if you're a lawyer and you've been involved in a trial, you know how time consuming it is when a trial's in session. As the government lawyers just did everything they can to put anything they could on the record to try to save their indefensible case, which is that you can't require, and the government can't get in the business of requiring corporations to engage in sex discrimination. The court was having none of it. Her verdict eviscerated this critical theory approach. And there were all these specific all these specific hurdles. The government, in theory, there are possible ways that the government can engage in discrimination that's otherwise prohibited. But it's obviously very narrow. Like, for instance, if someone's been discriminated against, the government can take a position that person should be made whole again. And you could argue, well, that person's benefiting from their race. Well, they were punished because of their race. So that's the sort of really narrow case. You got discriminated against and you're made whole again. And that's not even really racial discrimination promoted by the government. That's just justice, right? But they didn't bother with any of that. And the court saw through it. The law requires, and this is what the law is, it's based on Senate Bill 826. It requires every publicly held corporation headquartered in California to have at least one director who self-identifies. So I don't think we even got into the whole issue of identifying. as a woman versus being a female, born female, on its board of directors by December 31st, 2019. So it required at least one by 2019, and also required corporation to have up to 3 such persons on their boards by December 31st, 2021, depending on the size of the board. So the bigger the board, the more women technically they needed to have in order to achieve this quota mandate. Judicial Watch argued that the quota, and we argued on behalf of taxpayers who have the right to challenge illegal expenditure of government funds for illegal purposes like this under California law. And we argued that the quota for women on corporate boards violates the Equal Protection Clause of the California Constitution. And the judge in that case, Maureen Duffy Lewis, Superior Court judge, a veteran judge, agreed and determined that SB 826 violates the Equal Protection Clause of the California Constitution and is thus enjoined. I want you to think about that phrase for a minute, because it's often bandied about. It's obviously an Equal Protection Clause in the California Constitution. The Equal Protection Clause is enshrined in the 14th Amendment. And you have to remember, it seems to me, it's useful to remember that the rights enshrined in these governing documents, such as the California Constitution or our federal Constitution, are rights that we have separate and apart from the Constitution. The Constitution recognizes rights we already hold. They're God-given rights, and I mean that literally. They're divine rights. They're divinely given rights that we have as human beings, children of God, to be treated equally before the law, without discrimination, equal protection of the law. And in California, the radical revolutionary left has decided to assault that core constitutional principle, that core human right of equal protection under the law. And if you lose the right of equal protection under the law, and I don't mean it's a violation of the explicit text, I'm just talking about it in principle. If we don't have equal protection under the law, that way lies dictatorship, authoritarianism, totalitarianism, you name it. The government is unchecked and uncontrolled. And the left thinks they can erase that concept, equal protection under the law, using this critical theory approach. That there's systemic racism, systemic sexual discrimination, and that certain races or genders need to be raised up because because they have specific qualities. It's racism. It's racism, pure and simple. And in this case, sexism. Now, remember, this is the second case that we brought. The other case we brought was another crazy law. And I say crazy, I don't mean to say it's silly. I mean crazy meaning it was so outside our constitutional norms that went beyond the gender requirement for quotas to include include race, ethnic identity, and LGBT status. And in that case, a court that we pursued, and we didn't have a trial on that one, the court said we didn't even have to go to trial. He could make the decision on the papers and summarily dismissed or summarily affirmed our position that the law was unconstitutional, and also it's also a deadlock. And in this case, the judge issued a 23-page verdict, and I encourage you to read it because it's a scorcher. And she specifically found that the law's goal was to achieve general equity or parity. Its goal was not to boost California's economy, not to improve opportunities for women in the workplace, nor not to protect California taxpayers, public employees, pensions, and retirees. Frankly, none of those goals would have been appropriate to justify race discrimination. Further, the court found that putting more women on boards demonstrated that the legislator's actual purpose was gender balancing, not remedying discrimination. There's no compelling government interest in remedying discrimination in the board selection process because neither the legislature nor defendant could identify any specific purposeful intentional or unlawful discrimination to be remedied. We spent 28 days listening to them make up things as they go along. I mean, that's how I perceived it. And of course, the response of the government to this is, and the leftists who promote it is that, well, it's a shame we can't fix discrimination. The court said you didn't prove discrimination to be fixed. And also the court was offended by their approach. Let me quote you from this part of the ruling. This is one of my favorite parts. The court agreed with Judicial Watch and found that California, quote, had offered the testimony of stereotypical virtues of women, such as consensus builders and, quote, less risky behavior in investments. The court is unpersuaded by this offer of stereotypes for a justification of the law. So that's this is what they were doing. They were insulting the court and the intelligence, everyone who was following this, and of course citizenry, that somehow women bring these special qualities because they're, quote, are women. That's sexist. It's sexism, according to the left, right? All bets are off when it comes to justifying discrimination by this crowd. And the court found that we had presented persuasive evidence of illegality of activity. So it was unconstitutional and illegal what was going on. So this was a tremendous victory. It comes on the heels of another court decision, as I said. So there's two for two in California in terms of challenging the radical politicians' their efforts to blow up our laws against anti-discrimination, to blow up our constitutional protections, to blow up our civil rights. And you can bet if we had lost these cases, I hate to think we would have lost, other states would have been out of the gate quickly trying to enforce quota mandates despite discrimination prohibitions in state and federal law to the contrary. This is the second decision finding without a doubt that quotas for corporations are unconstitutional. The radical left's unprecedented attacks on anti-discrimination law suffered another stinging defeat. And what's interesting is I saw a New York Times piece, which of course is a leftist publication, and the New York Times article was, oh, well, it's too bad this law went down, but don't worry, it did its job. It got more women on the boards. Well, how did it do that? Through discrimination. Think about the theory of the case here. If you require that certain slots be reserved for certain people, you're telling other people they can't apply. So if a slot is reserved for an LGBT candidate, a black straight female can't apply. Right? No males can apply. Unless maybe they're LGBT, and they may be given more weight than the female. It's just crazy town to engage in this type of discrimination. It's so pernicious and so divisive and so dangerous. This racial separatism, this encouragement of racial identity, sex identity, it's so divisive and it's so dangerous. Because they think the consequences are all positive. And we're seeing in our society every day, this racial division is deadly dangerous, deadly dangerous. In addition to being unconstitutional and illegal. And it blows out of the water the canard that the left is against discrimination. They are the biggest proponents of discrimination in modern American history. This was, for instance, the most blatant attack on our nation's anti-discrimination legal infrastructure in 50 years, 60 years. It would have blown up the 14th Amendment. California Constitution reflects the 14th Amendment understanding. So this is a big deal, guys. This is a big deal. I know we do a lot of work on FOIA to expose government corruption, but here we had the government trying to destroy our social fabric and our constitutional systems that protect our civil rights. Clear and present danger, clear and present danger. And Judicial Watch thwarted it through relentless and proactive court litigation. And I know the courts sometimes don't work the way we want them to work. We sometimes lose, but you only win if you're in court, trying to use them as they're designed to be used to apply and interpret the law in a rational basis, in a rational fashion, based on the plain language of the laws at issue and what the law requires, and get a good result. And we did here. So 2 judges in California. Now remember, California is blue, right? And, it's all these left wingers who, no, we can't abandon the rule of law in California just because we think there are a lot of liberals that live there. Look, in Maryland, we won that case against the gerrymandering. Democrat legislature created this outrageously partisan map that denied fair access to Republican or fair representation to Republican or other voters. And a Maryland court judge said that's wrong. She was a Democrat, the judge. And then in New York, Democrats lost there. New York is a big blue state too. And New York said, look what happened in Maryland in Judicial Watch's case. So isn't it remarkable that Judicial Watch has had its most significant successes in at least this year? It's the what have I done for you lately, right? In California and Maryland, 2 of the blue states in the nation. It's those places where the rule of law probably needs the most protection, right? And where we should try to be most active. And more is coming. We've got more election integrity litigation and more. We're on continued battles exposing this critical theory revolution, this Marxist revolution that has overtaken our federal government, our military, our schools, and our corporate and media culture. And Judicial Watch keeps on winning, especially in this area of leftist blatant discrimination by government. We sued Mayor Lori Lightfoot, the far-left mayor of Chicago, over a racist interview policy that she instituted, where she said she would only talk to certain journalists of color about her government service. Talk about standing in in this case, City Hall's door, telling people, journalists, they couldn't get in based on the color of their skin, effectively. Outrageous. And we filed a civil rights lawsuit on behalf of Thomas Catanacci, who had asked for an interview. He was a white male, didn't get it. And his colleagues at the Daily Caller News Foundation, it was a civil rights lawsuit. Again, Judicial Watch is, in my view, the most preeminent and important civil rights organization out there, or at least one of the most. There are many of our colleagues in the conservative legal movement that protect and advocate on behalf of First Amendment freedoms in the religious sphere that are similarly important, and other free speech issues. But this is where civil rights is at, in terms of these are where the threats to them that we hold precious are focused. Be people being targeted because of their race by the left. In this case, Lori Lightfoot, Mayor of Chicago. Lawsuit last year in May, about a year ago, after Catanacci, a white journalist, emailed Lightfoot's office requesting a one-on-one interview with the mayor. The mayor's office never replied to the request for 2 additional follow-up emails. He came on one of the days that the mayor admittedly was discriminating against journalists based on race. So she had people in that she was talking to because of their race and denying access to others based on their race. So we engaged, so this case moved forward. They didn't want it to move forward, and the court allowed it to move forward. We took depositions, we took discovery, and as it's moved forward, Lightfoot comes out and tells the New York Times she would absolutely do it again. So that resulted in some questions that we had for her office and her spokeswoman. And so essentially, she has said through her spokeswoman, who's testified to us under oath, she admitted that she won't do it again, as testified to by her communications director and stated in her motion to dismiss. Mayor Lori Lightfoot has no plans or intentions in the future to exclusively provide one-on-one interviews with journalists to cover. So the discrimination, at least there, is over. So we're very proud of our clients for standing with us there. We, and this is the quote from Thomas Catenacci. He was pleased by the outcome. I'm glad that Mayor Lightfoot finally realized that her racist policy was untenable. I hope all elected officials take note of our case and think twice before issuing similar policies. That was very nice. He could have been a lot nastier there. All right. It's amazing and sad that we had to do this in America in 2022. A government official discriminating based on race is as wrong as it gets. We are relieved that she finally relented, said Daily Caller News Foundation President Neil Patel. And I said it is incredible in this day and age, following on that theme, that it took a federal civil rights lawsuit to force the mayor to retreat from a racial discrimination against reporters. And so we were aided in that case by Christine Svensson of the Svensson Law Offices in Chicago. Christine's a great lawyer. But this is tremendous work again by Judicial Watch. They got another good result. They backed off from this discriminatory policy. And we are the watchdogs, not only here in Washington, but elsewhere. So it's not corruption only in DC we have to worry about. As I said earlier, it's in California, it's in Maryland, it's in North Carolina. And obviously it's in Chicago. So I don't need to tell you that, right? And of course, we're only able to do this work with your support. And I encourage you, if you want more successes like this, and even if we don't get the successes, if you think these issues should be fought for and litigated, and if you think Americans, as a result, should be educated about what's going on, I encourage you to support Judicial Watch. You can go to our website at judicialwatch.org. We're on Facebook, YouTube. This day and age, I probably don't need to tell you how to find Judicial Watch. But I encourage you to support the work and at least get the work out. Share it with others. So a lot more is coming. Thank God for our great lawyers. And again, thank God for our supporters as well. And so if you're a supporter of Judicial Watch, thank you. Financially, if you support us, thank you. If you support us prayerfully, thank you. If you support us morally, thank you. If anything you do to advance our cause, we're appreciative of. You can be sure of that. With that, I wish you the best, and I will see you here next time on the Judicial Watch Weekly Update.
Thanks for watching. Don't forget to hit that subscribe button and like our video down below.